in the matter of the marriage of Brianna Lee Harbor and Jake Joseph Harbor.
John Sutton appears along with Jake Harbor via Zoom, the respondent.
Ms. Levitt, what is the current status of the divorce case?
Thank you, Judge. We have mediation scheduled with retired Judge Powers on February 27th. Unfortunately, when we reached out to both him and retired Judge Schmischer, they had like one January date, one early February date, and then the rest of their dates were all in the back end of February, which probably was, I should have expected, but I was hoping for sooner. We are set though now for February 27th for mediation. The way Judge Powers conducts his mediations, he starts them in the morning with the goal of being done at a half day, but he makes himself available for the entire day so that as the parties are making progress, if he needs to continue into the afternoon, he can. And both parties are prepared, or I know my client is, and Mr. Studman has indicated his client is prepared to fully participate in that. Beyond scheduling mediation, Judge, the IWO has finally processed through. We had an interesting response initially from Mr. Harbor's employer. They put that he had $0 in disposable income for an income withholding order, but they did withhold from his paycheck on January 10th. So we have finally had a successful withholding on the income withholding order. I will tell the court that there has now, though, only been 2 support payments paid throughout the course of this case. The payment made by Mr. Harbor after our last hearing in that cashier's check, which was $2,637, and then the biweekly amount from one withholding on the income withholding order of $1,332.46. So we do still have a significant arrears that remains on this case. I do believe that's appropriate to address in mediation, but I am raising that issue because there are lots of bills that are beginning to go or have gone now since our last hearing unpaid due to the lack of money coming to my client. She makes significantly less than Mr. Harbor and only can extend funds so far. In particular, we are concerned because the mortgage is now behind and that is their largest asset. Mr. Harbor also seems to have some unpaid bills as well because there are solar panels for electricity, some energy efficiency work that was done on the home that were turned off by the company because the bill was not paid for that. As it relates to the children, Mr. Harbor has not had any sessions with Dr. Goodman and the children. So although mediation is scheduled and I am still confident that Judge Powers and Mr. Studman and myself will make significant progress in that, since our last hearing, there really has been essentially no change. My client has continued on doing what she can to pay the bills with the funds she has, which is the best she can do. She continues to take the children to Dr. Goodman. They have had individual sessions, but Mr. Harbor has not scheduled or participated in any sessions with him and the children and Dr. Goodman.
All right. Anything else at this time, Ms. Levitt?
Nothing else that I believe is presently relevant, Judge.
All right, Mr. Studman, the court's first question for you and your client would be that if his employer wasn't withdrawing child support from his pay, how come he wasn't voluntarily paying it?
Your Honor, and just to address that, because I'll address both of those issues. There was an issue with the mortgage payment. He was contacted about prior to the end of this past year that they were in pre-foreclosure. He did catch the house up at that point, which was a little over $3,000 or 3 payments. So he did make that payment. I know that was originally in the temporary order for the petitioner to pay, assuming she was getting funds from my client. So he did make a substantial payment on the mortgage just to catch that up, and has made the mortgage payments since. So that has been being paid. So he is, I know that wasn't ordered in that way to pay, but he has been supporting in that manner at least. He just was notified of another bill on the internet that he caught that up for another $500. So it's not like he hasn't been paying anything. He has been helping, and now that that order is in place, I think maybe we can get all these bills kind of caught up and get who's supposed to be paying them, because the petitioner will be getting these funds regularly, and we can figure out what needs to be offset with the payments that he has made. So there has been payments made, and we apologize for that mess. It was a little bit of a mess, but we're hoping we can get that all resolved through mediation as well. I just wanted to address the issue with Dr. Goodman. My office will contact him immediately. My client was awaiting word from Dr. Goodman's office to get him scheduled in with the kids. And so I will make sure my office contacts his office. I don't know that they've reached out at all to him to get that scheduled. We'll make sure we reach out to make sure that happens. It was supposed to be sessions with the children individually, and then they were going to start incorporating my client, and that's never happened. So we will do that. We have obviously no objection to that, and we respect Dr. Goodman very much, so we want that to happen. So yes, that's where we are. Like I said, this case got off to kind of a messy start, and we're hoping to kind of fix all of that as we go forward and deal with this. So yeah, we're hopeful to spend the day with Judge Powers and see what we can get done on the case, Your Honor.
All right. The court's next question, I'll turn back to Ms. Levitt at this point. We've still got this pending protection from abuse case, and frankly, this court does not favor someone filing an abuse case, not prosecuting it, and just using it as leverage in another type of domestic action. It's a tactic sometimes used. Again, this court does not favor it, and frankly, personally, I don't like it. So what about this abuse case? Is there any reason to keep this going?
Your Honor, my client's position she has continued to maintain that she believes that she can meet the burden for a PFA and wanted one for herself individually. Obviously, we have transitioned with the children with Dr. Goodman involved to therapeutic parenting time. And as the court may recall from our last session, with the goal of growing away from therapeutic parenting time to what will look like normal parenting time. I mean, I know normal is different for everybody, but obviously not involving the therapist is what I mean by that. For herself individually, my client did still want a PFA. She is prepared to proceed to hearing on that. However, I will be frank with the court that Mr. Studman and I have not further discussed the PFA at this stage because of the other issues in this case. In terms of there's a whole host of financial issues that are involved in this case beyond what has even been shared with the court today. And I do think that Mr. Studman and I could probably reach an agreement on orders in the divorce case using our family wizard, which the court had said that previously that you would approve, that would give my client that distance that she feels is appropriate. She doesn't want Mr. Harbor showing up at the house uninvited, things like that, third-party parenting exchange locations when it shifts away from Dr. Goodman's office that do not necessarily require it to be under the PFA case filing.
I trust this is an issue that can be reasonably discussed either before or during this mediation that's scheduled?
I believe so, yes. And I won't speak for Mr. Stedman, but I know how he and I have worked cases before individually and things like that. And I think yes.
All right. Mr. Studman, is there anything that you would add to that discussion?
Yes, I mean, no, I believe Mrs. Levitt is absolutely correct. We and there's been no contact. My client has respected the distance this whole time for all those reasons, to give some comfort to the other side, let them know that we are serious about pursuing this therapeutically. So given the fact that there hasn't been any issues going forward, I believe it is something we can address through mediation, and there are things that we can suggest to put into place that would give that protection that she would otherwise have through a PFA. So I believe it is something we can work through, Your Honor, and we would like the chance to do that through the mediation process too.
All right, thank you for your statements, Mr. Studman. Obviously, the court encourages and supports the mediation to take place in late February. This court wants to establish another court date in March, late March. And the reasoning for that would be, number one, I don't want to lose track of this case. Number two, court wants to be advised as to the results of the mediated settlement conference, which is contemplated. And I want to allow enough time that should the mediation be successful and that we have a comprehensive resolution of issues, to give the attorneys a couple of weeks to get an appropriate decree or settlement agreement or both drawn up. So I think a late March court date would be appropriate. Again, this would be for Zoom. And possibly could be a final hearing in the case if we're fortunate enough to reach final resolution on all issues. March is a really jammed month for me because of trials. But let me see what I can do here. I would be looking at the morning of Monday, March 31. Counsel, your schedules that morning?
Judge, I'm available all morning.
I'm available, Your Honor.
Okay. I would set this at 10 o'clock a.m. by Zoom. I encourage the attendance of the parties that day. And obviously, if we need to present evidence in support of the petition, the petitioner would be required to be there.
Yes,
Monday, March 31, 10 o'clock for Zoom status conference. Again, I encourage the parties to participate in the mediation in good faith and try to reach an appropriate resolution of all issues, keeping in mind the best interest of the children on any child-related matter. Mr. Studman, let me ask you first, is there anything further we need to pursue at this time?
Not by the respondent, Your Honor.
Thank you. Ms. Levitt, anything further we need to pursue at this time?
Judge, I just have one question, and quite frankly, it's more for Mr. Studman than for you. My client does not have access to the mortgage documents because everything is only in Mr. Harbor's name. So we were unaware that he had made those catch-up payments on the home. I was hoping that documentation of that could be shared with my office or my client directly. I would prefer through my office, given that the PFA is not resolved yet, so that we can see. I believe what's been stated here today, but I always like to document and verify, and my client would like to see that as well. And then part of the reason why she does not get mortgage documents, it may be because the mail is being forwarded to Mr. Harbor, but also because she does not have a mailbox key. So we do need access. That's literally the mailbox, like at the residence. She has had to redirect her mail to be picked up at the post office, and she can't access it. So we do need, it has been a workaround that has been working, but we would like to avoid continuing to use the workaround if a mailbox key could be provided. And then Mr. Studman, one last thing, you were going to send me your client's alcohol evaluation last time, and I did not see an email with that, and I may have overlooked it. So I apologize. If you tell me I got it, I will go back and look for it, but I don't think I did. It's
right here. I actually was checking on that this morning. Mr. Harbor had brought that in when we asked it to, and I don't know if it went to you or not. So I have it right in front of me. I'm going to shoot that to you right now. No issues with getting the verification on the mortgage, and we'll maybe you and I can talk too. If your client's going to be paying that going forward, we're going to need to get her in a position where she can get online and do that. And then we'll see about a key to the. That's the key to the general mailbox, and she can't get into the mailbox to the house.
Yeah, she says that's the mailbox numbered 382.
Yeah, we've got a PO box that doesn't do street.
Oh, it's a PO box.
Yes.
Oh,
Okay.
But it's free with the house.
Oh, I apologize. It is a PO box, but it was assigned to the house and came with the home. So in my head, I was thinking it was the home mailbox. And it is, but it's actually a PO box separate from the residence itself.
We can provide that too as well. That shouldn't be an issue.
And I could have my file clerk come and pick that up so that there's no interaction between the parties.
You'll let Ms. Levitt's office know when that's ready, Mr. Studman?
Absolutely, Your Honor.
All right, very well. That appears to address all issues which might be before the court at this time. Again, we'll conduct a status conference Monday, March 31, 10 o'clock a.m. by Zoom. And again, the court expects the parties to participate in good faith in the mediation, which is scheduled for February 27th. Good luck in that regard, folks.
Thank you very much.
There's nothing further. This matter will currently be in recess. In the District Court of Butler County, Kansas, case entitled "In the Matter of the Marriage of Brianna Lee Harbor and Jake Harbor," case number 2024 DM 276. Counsel, this is a review stemming from proceedings held on January the 17th. At that time, it was expressed to the court that the parties intended to participate in mediation with apparently retired Judge Powers on February 27th. What happened on that date?
Yes, Judge, we have settled all the matters between the parties. A journal entry of judgment and decree of divorce, permanent parenting plan, child support worksheet, and an order resolving the PFA have been drafted by my office. I need to finalize those following this hearing today and send to Mr. Stedman for him and his client to review and sign. But the matters between the parties are officially settled.
All right. What about the other pending case that ran along beside this one for the last 8 months?
Yes, Judge, the PFA has been an agreement of the parties is to dismiss the PFA, everything that needed to be addressed in terms of the parties' communication and contact is written out in their journal entry and parenting plan instead. And I have an order of dismissal drafted for that as well.
All right. Answered my question. All right, Ms. Levitt, this court will require testimony in support of the divorce petition in the case. I trust your client will be testifying in support of that petition.
Yes, Judge, she's prepared to do so this morning.
Ms. Harbor, if you raise your right hand, please. Court will administer an oath. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
You may question the witness, Ms. Levitt.
Thank you. Ma'am, can you please state your full name for the court?
Brianna Lee Harbor.
And you're the petitioner in this matter, correct?
I am.
And who is the respondent?
Jake Joseph Harbor.
And he's your husband currently, correct?
Yes.
And you filed a petition for for divorce on August 7th, 2024, yes?
Yes.
Okay. And you asked the court to grant you a divorce based on incompatibility. Can you please explain to the court how you and Mr. Harbor are incompatible?
We don't get along. Counseling never changed that. We have tried counseling. We're better off separated from each other. And we want different things in life and our marriage for our family.
Are you asking the court to make a finding that the two of you are incompatible and grant you a no-fault divorce today?
Yes.
And alongside that, are you asking the court to make a finding regarding the division of debts and assets?
Yes.
Okay. And as well as a parenting plan for your minor children?
Yes.
Okay, let's address the parenting plan for the children first, okay? Can you please tell the court the names and ages of your 3 children?
Scarlett Rose Harbor is 10 years old. Jake Bradley Harbor is 9 years old. And Ophelia Grace Harbor is 7 years old.
And you all have entered an agreement, or you're about to sign an agreement that grants you joint legal custody, correct?
Yes.
Okay. And then it sets forth a specific parenting plan wherein you have primary residency of the minor children, correct?
Yes.
Okay. And father, Mr. Harbor, has kind of a multi-step approach to growing his parenting time, correct?
Yes.
Okay. And it starts with him doing therapeutic parenting time with the minor children and their therapist, Dr. Goodman, yes?
Yes, but with that being said, it is my understanding he is welcome to attend doctor's appointments, so he will actually see them for the first time in 9 months tomorrow at Scarlett's follow-up because she had an emergency tear to her hand and got 14 stitches. And so he said he wanted to be there. And to my understanding, that's acceptable. And so he's going to be there for her doctor's appointment for the first time to see her in 9 months. I haven't got any follow-up on the meetings, but yes, it's in place that's where the visitations would start, aside from doctor's appointments and emergencies.
Okay. So doctor's appointments, emergencies, and therapeutic parenting time is step 1 then?
Yes.
Okay. And then step 2, once Dr. Goodman and has advised the parties that it's appropriate for the children, father will be moving to supervised parenting time with family friends monitoring it, correct?
Yes.
And that is intended to proceed for several weeks with therapy still going on with the children with Dr. Goodman, correct?
Yes.
Okay. And then following supervised parenting time, the 3rd step is to move to unsupervised parenting time based around the children's school schedule and dad's work schedule, correct?
Yes.
And the parties have agreed to revisit the exact schedule before the school year starts in August of 2025, correct?
Yes.
In addition to
a parenting plan, you all reached an agreement regarding child support for the children as well, correct?
Yes,
And that child support sets child support in accordance with the Kansas Child Support Guidelines.
yes,
And you guys have agreed for your income to be set at $35,772, yes?
yes,
And father's income to be set at $121,068, yes?
yes,
And he will continue to provide health insurance for the minor children.
yes,
And you will claim the children for tax purposes and father will get an adjustment on the worksheet for that, correct?
yes,
And you also have reached an agreement regarding the financial aspects of your divorce, correct?
yes,
Okay. And I'd like to go through that, starting with your division of assets, okay?
okay,
You have asked that the court award you, and Mr. Harbor agrees that you should be granted your vehicle, a 2021 Nissan Rogue, your bank accounts, including a now closed or a what is believed to be closed Unity bank account and an open ones that you're using at Emprise Bank, as well as your personal belongings and effects. Is that correct?
yes,
And you're asking that Mr. Harbor be awarded, which he agrees, 2 vehicles, the Toyota RAV4 and a Chevy Silverado, all of his tools and work uniforms located in the garage, the marital residence, which he may schedule a time to pick up.
yeah,
His firearm, which he will have to get returned to him through the Benton Police Department,
yes,
and then his bank accounts with Central National Bank and Emprise Bank, and then his Robinhood and retirement accounts, and finally his personal belongings and effects. Is that correct?
yes,
And in exchange for those divisions of debts and assets, you all have worked out a few other agreements, and I'd like to go through those as well. You have agreed that you both will place the marital residence for sale, correct?
yes.
And can you tell the court the address of that marital residence?
314 South Norris, Norris in Benton, Kansas.
And that'll be placed on the market at a date to be agreed upon between the two of you, but with the intention that you and the children can live there through the end of the school year with a leave date of June 15th, 2025, correct?
Yes,
And from the sale of the home, initially repairs and costs will be paid out of it, correct?
yes,
And then an equalization payment will be paid to you to account for the division of debts and assets out of that money in an amount of $33,146.24, correct?
yes,
And then any additional proceeds will be divided equally between the parties, correct?
yes,
You guys also had debts that you were dividing. I'd like to go through those. You're asking that the court assign you the responsibility for the monthly utilities at the marital residence, correct?
yes,
The mortgage payment until you leave, correct?
yes,
And then the responsibility for taxes and insurance on your vehicle, as well as payment of your credit cards at Von Mar and a Chase Bank for an Amazon Visa, correct?
yes,
And then you also have loans that you'll be paying through Credit Union of America and Emprise Bank for your vehicle and personal matters.
yes,
And you will be responsible for your own student loans through Aidvantage, correct?
yes,
And then father is going to take debts that are in his name, including rent and monthly utilities for where he's residing at, correct?
yes,
Taxes, and insurance for his 2 vehicles, is that correct?
yes,
And then his regular and reoccurring payments with Emprise Bank loan, the window loan for the residents, a Home Depot credit card, a Cabela's credit card, and the outstanding balance with the IRS, correct?
yes,
And I forgot to ask you with the home, you said you told the court that you were going to pay expenses out of the home. You also are paying off the window loan and the solar panel loans with the sale of the home, correct?
yes,
And because of the equalization payment and this division of debts and assets, you will not be receiving what we would typically call spousal maintenance, correct?
yes,
Do you believe that the parenting plan described here today is in the best interest of the minor children?
Yes,
Are you asking the court to adopt that as its order today and as it'll be sent in filings later this week?
yes,
And then do you believe that the property settlement is fair, just, and reasonable?
yes,
Are you asking the court to adopt it as the property settlement between the parties?
yes.
Judge, unless the court would needs me to inquire further on any issue, I have no further questions.
Mr. Studman, do you have any questions for this witness?
I do not.
All right, very well. And Ms. Levitt, that is your entire presentation to the court?
Yes, well, Judge, also, I will put on the record that an order of dismissal in the PFA will be filed, and it will reflect that in the parenting plan, the parties intend to communicate about the children using our family wizard. I did leave that out, and I want to make sure that that's clear because that has been pending for a while, and I know the court wants to make sure that that gets wrapped up as well. So there will be a dismissal that references the parties need to follow the orders in the parenting plan for contact and communication.
Understood, counsel. Mr. Studman?
I don't have anything further, Your Honor. That's all correct.
Very well. Very well, then, following the evidence that's been presented and after review of the files in this case, the court does find that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent on the legal ground of incompatibility. The marriage of the parties is hereby declared to be dissolved. Court further finds that the parties' agreements regarding a parenting plan appear to this court to be in the best interest of those minor children. The court will adopt the parties' agreed parenting plan and make that the orders of the court at this time. Court further finds that the parties' agreements regarding financial matters, property, and debt are fair, just, and equitable to both sides. The court will approve the parties' agreements and make those the orders of the court as well. I don't know if that was covered in testimony. I want to make sure I understand. Is the petitioner in this case seeking a restoration of a former name?
No, Your Honor, she is not. She'd like to keep the name Harbor to match the children.
Or then the court will advise the parties that under the laws of the state of Kansas, you're not divorced based on this oral pronouncement from the bench, but rather when your decree of divorce gets approved by the judge in the case and then filed with the clerk's office, it is the filing of that decree, which is the act that divorces you under Kansas law. And then for a period of 30 days thereafter, you should not try to remarry. Any marriage you would attempt to enter into during that period would be voidable under Kansas law. So wait a few weeks after your decree's filing date to attempt to enter into a new marital relationship. I hope you parties can continue to work together for the best interest of your kids under circumstances which make them comfortable and make them feel that they have a father in their life and a mother in their life that care about them. So good luck in that regard. I hope that you can continue to work together for their best interests. Ms. Levitt, I'll look forward to receiving the documents that you referred to today for the court signature. And I'll ask you, Ms. Levitt, is there anything else that the court needs to address as part of the record of these proceedings?
Not at this time, Judge.
Mr. Studman, anything further at this time?
No, Your Honor.
Very well. And if there's nothing further, the Harbor matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.
Thank you all.